Okay, welcome to Uxbridge FM's legal show. And today our subject is lasting powers of attorney. And we're welcoming back Alannah Macdonald from the Sethi Partnership Solicitors based in Eastcote. Hello again, Alannah.
Hi there.
Thanks so much for popping back. Now, lasting powers of attorney, what does that even mean? What is an LPA?
So, a lasting power of attorney, or an LPA, basically gives somebody, often referred to as an attorney, the authority to carry out things on your behalf. So, you're known as the donor, and it's only as and when you're unable to do so. LPAs were introduced by the Mental Capacity Act and replaced things called enduring powers of attorney, which some of your listeners may be aware of. The idea was that an LPA offered more flexibility than an enduring power of attorney and could be used in advance of somebody losing capacity. It was recognised that not everyone lost capacity as they got older or in general, and sometimes that it was mobility that became an issue. So LPAs allow for that and offer that flexibility rather than just assuming everyone's going to lose capacity later in life.
Okay. So who and why needs an LPA?
So anyone over the age of 18 can have a lasting power of attorney, provided that they understand what the document is when they're signing it and when it's drawn up, and they have to have the capacity and fully comprehend the document once it's being drawn up. The LPA allows you to deal with somebody's property and financial affairs or make health and welfare decisions on their behalf if they're unable to do so. It also allows people that flexibility that if they're unable for whatever reason, whether it be they're on holiday, they're in hospital, it gives them the opportunity to send somebody in their place or act on their behalf. It could be a conveyancing transaction, for example, buying and selling a house. If you're away on holiday or you're away on business, it would allow your attorneys to act on your behalf for you.
Okay. There's different types of LPAs, is that right?
Yes, there's two types of LPAs. One is the property and financial affairs, and one is the health and welfare decisions. Now, the property and financial affairs lasting power of attorney allows your attorneys to make decisions which deals with anything of a financial nature. That could be paying your bills, getting your shopping, dealing with investments, as I said, selling a property. It could also be claiming or receiving any benefits or your pensions, even down to filling in a tax return form. So it's about anything of a financial nature, dealing with your bank accounts for you. As I said, anything where it's money related will come under that particular lasting power of attorney. The health and welfare one, on the other hand, allows people to make decisions which relates to the donor's personal welfare. So this could include making decisions about where the donor resides, giving or refusing consent to medical treatment, together with more day-to-day decisions relating to diet, daily routine, activities, could even be daily medication. It also makes provisions for social services support and community assistance, as well as accessing medical records.
And do I need to get both of them, or could you have both at the same time?
Honestly, it's entirely up to the individual as to what LPA they do or don't do. The property and financial affairs lasting power of attorney will only allow an attorney to make decisions about the property and financial affairs relating to that attorney. So you can't get a property and financial affairs and expect it to cover both that and your health and welfare, as well as a health and welfare one won't allow you to cover your health and welfare and your property and financial affairs. So they're two very individual documents. And the reason being is that you can ask people to act for you in different ways and on different forms. So you don't have to always even appoint the same people. So although we always say to clients, both of these LPAs are extremely important, the most important, if you want to deem it that way, out of the two of them is the property and financial affairs lasting power of attorney. The reason being is if the bank account or savings, investment, property, whatever it is of a financial nature is in your name and your name only, technically only you can deal with it. Obviously, it would create major problems for your family if you need to have something changed or altered in any way and you didn't have the capacity to deal with it yourself, whether, as I said, that be because of a mental capacity issue or you were just unable to physically contact the company. It could be a hearing thing, obviously calling insurances over the telephone to discuss policy changes or amendments to that policy. will be quite difficult, and it saves you giving authorisation every single time that something needs to be done.
So is there a recommended age to get this?
So, like all legal documents, you have to be over the age of 18 to create a lasting power of attorney. And of course, as I said, capacity is the main issue. You have to have capacity to actually draw up the document. The majority of people that consider a lasting power of attorney is usually around the age of 40s and 50s. It's where their own children may have reached the age of 18, so they're likely to put a spouse or a partner, if they have one, as an attorney, but also children as either replacement attorneys or to act alongside their spouse. It just means that at that point, they're likely to be more aware of what's going to happen to them if they lost capacity or if they started struggling later in life for different reasons.
And can anybody act as an attorney, or do you have to be a family member or linked to that person?
No, you can appoint family, friends. You can even appoint professionals such as solicitors or accountants to act on your behalf. We always say to people, only appoint people that you can actually trust. So it's no good appointing somebody like a family or friend member that's no good with their own money, because they're not going to be very good with yours. We usually say that they have to be obviously over the age of 18 themselves. They also have to have mental capacity themselves. It's a thing that runs throughout LPAs. Capacity is a huge thing. In relation to property and financial affairs, lasting powers of attorney, the attorney must not also be bankrupt or subject to any debt relief orders at the time of appointment. If they become subject to any of these at a later date, then their appointment can be terminated and it could revoke your lasting power of attorney. So it's very important who you do choose and sort of why you choose them. As I said, most clients will appoint family and friends that they can trust. Where they don't have any family members, they may appoint a solicitor in relation to their financial affairs lasting power of attorney, and then friends for their health and welfare. So it's entirely up to the individual.
So could you have more than one? And if so, what would happen if they had an argument and they had differences of opinion on things?
So there's no set numbers of attorneys that can be appointed. You need to bear in mind that obviously, as you said, the more you appoint, the more opinions they're going to be, especially if they have to be making decisions unanimously. So it really depends. There's a number of ways to appoint attorneys. The most sensible is something called jointly and severally. It means that your attorneys can act together but also independently. It's usually the best in terms of location, because not everyone lives on top of each other. Not everyone can always be there together at the same time. If you're appointing your attorneys, however, to act jointly at all times or jointly for some decisions and jointly and severally for others, then yes, they have to agree. As I said, the more you appoint, the more differences of opinions there's going to be. At first instance, the form does allow you to appoint at least 4 attorneys. You can add additional sheets in here. So if you had 5 children, it doesn't mean that you had to pick your favourite 4. You could appoint all 5. There's also a section to appoint replacement attorneys further on in the form as well.
Okay. And if I lose capacity, obviously lose my marbles, as we might say, how does that work?
So if you lose capacities, the attorneys that you appoint will be able to step in and act on your behalf. So in relation to your property and financial affairs, your attorneys may have been able to make decisions on your behalf as soon as the lasting power of attorney was registered, prior to you losing that capacity, but only with your consent, i.e. going to get your shopping if you were in hospital or going to get some money out, for example. If at a later date you then lost capacity, it would mean that your attorneys could still act on your behalf, or alternatively, it may be that they were only able to make decisions once you lost capacity. Therefore, they need to prove that you don't have the mental capacity in order to act on your own behalf, and they would step in. In relation to your health and welfare, on the other hand, your attorneys can only make decisions on your behalf when you don't have the capacity to do so, whether this is a temporary basis, such as a coma or being unconscious for whatever reason, or on a long-term basis, such as a neurological condition like dementia or Alzheimer's, or something due to a brain injury, say following an accident or illness. Each time your attorneys act, they have to prove that they are actually appointed your attorney. So you'll have banks and GPs actually asking who they are and what gives them the authority to voice their opinion or instruction in such a way. The certified copies of lasting powers of attorney, which are usually provided if a solicitor draws up the documents, are as good as the original. It keeps the original safe, like it would your will, but allows them to act quite freely. They'll also ask to provide photographic ID. Again, it just proves who they are and that their name matches the lasting power of attorney.
Then I assume at some point you're able to amend the LPAs if circumstances change or whatever.
In a way, yes and no. The document itself that you can draw up can't be amended. So once it's registered, if you do want to make any amendments, then you have to revoke the document itself, so very much like a will, start afresh, draw up a new document, and then register it again. So you can make any changes in between those situations. It's therefore important that you take time to consider who you're appointing. Obviously, if you appoint children, you have fallen out with one of those children, then it's probably best that you revoke it and start again. If it's a case that you've just had a small argument or they've moved away or died, it doesn't necessarily mean that you have to amend your power of attorney depending on how you appoint your attorneys.
So what's the process of drawing up the LPA? If someone's listening and thinking, oh, that would be a good thing to do, they go and see a solicitor, and then what happens?
Yeah, so drawing up a power of attorney with a solicitor is quite relatively straightforward. In most cases, solicitors like ourselves will offer a full service. This means that you supply them basically with names, dates of birth and addresses. That's all we need. And we do all the rest. So that will involve drawing up the document, arranging the signing with all the attorneys, obviously, and yourself as the donor. And then we will arrange for the registration of that document. We'd also act usually as something called a solicitor certificate provider, where the solicitor isn't appointed as an attorney. So that just confirms that you're of sound mind and that you're capable of understanding the document, you comprehend it, and you can go ahead and register it.
Okay. And then finally, if I've already lost my marbles and I don't have an LPA in place, that's a bit more confusing, I guess. You've got to prove that my marbles have gone.
Yes, if capacity is already lost, then an LPA is likely to be a suitable option. Therefore, it may be necessary to apply for something called a deputyship. It's very similar to lasting power of attorney, but it's where the donor has already lost capacity. So such applications are governed by a court known as the Court of Protection, rather than the Office of the Public Guardian, which governs lasting powers of attorney. However, they are very expensive and time-consuming. They usually cause a lot more stress, especially where time is of the essence. So if capacity is already lost, you kind of want to get the ball rolling a lot quicker. Court of Protection application is very long-winded. The deputyship application also requires a medical assessment by a doctor to prove that lack of capacity in the first place. And there's a number of additional fees required by the court in order for them to process the application. To name a few, it's a £385 court fee. It's a supervision fee of ranging from £35 to £320. It's a security bond for the Property and Financial Affairs Deputy, a new assessment deputy fee of £100, and a hearing fee of £500 if the court decides that your case needs a hearing. So in total, that's just £525 in court fees alone, prior to even obviously instructing a solicitor for assistance or even paying the doctor for their assessment of the donor.
Wow, so pretty serious costs involved.
Yes, so we always say to people, if you are going to sort of put that protection in place, speak to a solicitor or speak to somebody about a lasting power of attorney, even if it's to get the information, and that way you can then decide for yourself what you're going to do. We say to clients it's more of a safety net. We're not assuming that everyone's going to lose capacity. It could be that mobility becomes an issue later in life. So it's just having that safety net in place. It saves a lot of stress, a lot of time on your family at the end of the day, should they need to act for you in quite a quick scenario.
That's great. I've learnt so much again. Thanks, Alannah. And let's just give you like 30 seconds to promote Sethi Solicitors. Give us a quick overview of the kind of things you get involved in there.
So I'm one of the private client solicitors at the Sethi Partnership Solicitors. I deal with wills, powers of attorney, probate, declarations of trust, all of those sort of things. We are based in Eastcote. We've been there for over 20 years now, and we deal with a range of services, including conveyancing, both commercial and residential, litigation, immigration, divorce and family, and employment law. So we're quite wide-ranging. We can offer pretty much everything that the local client will need. Pop in and see us, even if it's just to say hello. If you need any legal advice, either myself or one of my friendly colleagues will obviously be able to discuss it through with you. Yes, we may be solicitors. We're not necessarily after your money. We'd rather give you the personal and tailored advice that you need, and then obviously give you the options to go away and think about what it is you want to do in those situations.
Fantastic. Well, thanks so much for coming in and talking to us today. That's been fantastic. I've learned, again, loads about LPAs.
Thank you. Lovely to meet you again.